a slightly different aspect. But otherwise, my lord, if on the facts and circumstances and on the appreciation of materials it is made of, that if the marriage is irretrievably broken down, then there is no cohabitation, parties have been living separately, they have been trading allegations, and my lord, they have been living separately for a continuous long period of time, and the litigation has also proceeded to some extent. Nevertheless, there is a recalcitrance on the part of one person, one of the spouses, my lord, not to consent for a dissolution of marriage, but say that I'll hold on to it, I'll make her pay, or I'll make him or her pay for it. Let them litigate for another. Then that is one of those areas where your lordships could come in and then say, this amounts to a cruelty.
That also happens often at times.
Yes.
Where somebody feels that, okay, you have spoiled my life, I will not let you leave here.
Correct. My lord, if it comes to that, my lord, why I respectfully submit that this may, of course, my lord, your lordships may have to elaborate on it, but that's your lordships may consider whether it is worth elaborating.
See, it's very, I don't know, speaking for myself, very difficult to think of all the innumerable
myriad situations, you know,
which may arise, especially in an interpersonal relationship. Correct. And where exactly we should work it out. Honestly, something like 136. Can you say what ground 136 will be worked out or not? You see it and you feel this is a case for 136 or not.
True.
Some variation will occur because court sits at different benches.
Though the law may not be completely in favor of interference.
Similarly, where to exercise, which factual scenario. Very difficult to enumerate, give all illustrations, give all possibilities. There it should be exercised. Issue here also before us is this, according to me. Are we entitled to exercise under 142?
Your lordship
is not setting down the norms where all we should exercise under. Either we have a right or we don't have a right.
No, my lords, the power under 142, my lord, pristine power under 142 is not cribbed, cabined or confined by any restraint, either flowing from the constitution or for that matter flowing from any statutory branch. It's plenary in character. Lord, I'm only repeating the words that this Honorable Court has used in several judgments dealing with that. Part of the compilation, Lord, at least 4 judgments deal with the power under 142. But I'm not taking up your lordship's time. I have given the relevant paragraph numbers also. Roypa, Lord, several other cases when Premchand Gar, Union Carbide, Supreme Court Bar Association, the BSP Rajana. All those, my lord, serial numbers 23, 24, 25, and 26 in this compilation deal with that. My lord, I have given the page numbers. No, my lords, therefore, there is no, it's not a case, my lord, where this Honorable Court would find that the power is not available. Because it's plenary in character and it's supposed to be exercised ex debito justitiae. Why would your lordships find that there was injustice? Lordships would find that there was injustice because you can't keep 2 persons who cannot say eye to eye, continue in the same manner. And my lord, probably throw the remaining members of the family also into disarray. Lord, by compelling them, no, you don't come under any one of the straightforward parameters of any one of the enumerated grounds, and therefore we will not interfere. This is one of those classic cases where your lordships would find that what is happening is injustice, and therefore your lordships would interfere. But that would be a pristine case of exercise of power under 142. Where your lordships have given it a name, irretrievable breakdown of marriage. Lord, this I invited your lordship's attention to only because there is an argument that in 2 judgments of this Honorable Court, it has been said that this Honorable Court decides that there is an irretrievable breakdown of marriage and grants a resolution in that regard. This Honorable Court is actually embarking upon a judicial legislation. And that is not something which is on embarked, and therefore it should not be done. There is also another argument that while doing so, the Honorable Court has probably would be contravening an express provision of a substantive provision of law, which again, my lord, I don't think is correct. There is no express provision of law or statute which is being contravened when the Honorable Court says that, yes, this is one of those cases where there is an irretrievable breakdown of marriage, and therefore it would be better that the parties are resolved to a degree of resolution of marriage as such.
It is an area where actually the legislature and its wisdom has not created a ground. So it's absence of ground, not prohibition of.
That's right. That's it. Therefore, my lord, please put it, my lord, this I would most respectfully come on for your lordship's acceptance. In exercising the power under 142, your lordships are not contravening any exception. Obviously, your lordships are not contravening any fundamental right. Obviously not. There is no substantive provision which is being expressly contravened. And it is only in that regard, my lord, as I said, that section 13 does not speak about an exhaustive enumeration of the grounds. That is not to say that one can invent ground and then go to the court and then see. That is why, my lord, I would respectfully submit this para 14, put it on that platform, which is discernible and textually available from a reading of section 13 of the Hindu Marriage Act. That an unusual, unjustified recalcitrance on the part of one of the parties to the marriage to cling on to it and not grant a divorce or not let the other party free, in spite of, my lord, there is an irretrievable situation of irretrievable breakdown of marriage, would probably amount to a mental cruelty, my lord, which is discernible clearly, my lord, under section 13, which is one of the grounds under section 13.
Which I think cruelty, we don't intervene.
I don't want to live with her. She also does not want to live with me. But then I cling on to it. Why? Only, my lord, in a manner of speaking, to exact revenge on my spouse. That, my lord, probably, that conduct by itself could amount to a cruelty. And if that is sufficient, and it is up to your lordships to discern from the facts and circumstances of each case whether it would amount to a cruelty, then I would respectfully submit there is no question of contravening any provision, but your lordships are only devising a tool by which your lordships would say, to do complete justice between the parties, we are saying that please part ways and go ahead and go forth in your life. You know, this is one of the aspects by which, or one of the methods by which your lordships could probably say that exercise of power under Article 142 does not really come across any, or it does not frontally assault any one of the self-restraints that your lordships have adopted for your lordship's sake in this regard. Lord, this is one aspect on which, my lord, I would respectfully submit that your lordships may kindly bestow consideration. But this is under 142. But when it comes to, my lord, the trial court or even the high court, my lord, dealing, that's the family court or the high court dealing with this, it's a slightly more tricky situation. I really don't know. My lord,
Mr. Giri, if you once accept clause number 14,
yes.
then how can you say that the trial court and the high court cannot go?
No, my lord, that's because, my lords, the accepting clause 14 and then transforming itself into a ground which is discernible under
This judgment is not under 142.
No, this judgment is not under that. That's right. That's it.
So if this is the ground of cruelty,
Yes, if it becomes a ground of cruelty, your lordships are
it cannot be done under 151. 151 is purely procedural. But if this is a ground of cruelty,
ground of cruelty.
Right.
Your lordships are right.
then it can be done.
Yes. Yes, my lord. I did not. It did not strike me.
In fact,
I vote on.
it's a long list of instances of cruelty, paragraph 101,
Yes.
on which decree could be passed under section 13. That's what
Yes.
pre-judgment says.
Yes, because all these would translate it into
That's it.
mental cruelty.
142 is excised by us
Yes.
because sometimes this ground is not specifically taken.
Yes.
Number one. Number two,
Yes.
during the passage of litigation itself, this ground emerges.
But, my lord, in my respectful submission, that probably, my lord, would mark the distinction between an exercise of power by your lordships
Correct.
and exercise of power by the trial court or the high court. In exercising a power of granting a dissolution of marriage on the ground of irretrievable breakdown of marriage, by bringing it under the broad heading of cruelty, there has at least to be a pleading by the party concerned that I have been subjected to a cruelty for the trial court or the high court to exercise a power. And at least that caveat should be.
Mr. Giri, the difficulty in that situation is
Yes.
the quality of pleadings, the quality of evidence led by the parties at the initial stage. And when we interact with the parties in the court,
Yes.
we understand, or when the arguments are addressed before us,
Yes.
that time we understand what is the underlining, or the differences have become so much that they cannot stand each other. They can't even try and negotiate with each other. And therefore, the very fact that you ask them to sit down and talk itself is a difficult.
No, my lord, but that is probably one of the grounds on which the court would come to the conclusion that there is an irretrievable breakdown of marriage. They can't even see eye to eye on this. But that's one of the classic tests, my lord, where this honorable court has formulated. They are not even willing to talk to each other, let alone negotiate. The negotiation at that point of time is only on how much money is to be paid by one party to the other, probably on custody of children. What is non-negotiable by both the sides is that we don't want to live with each other. That is when your lordship would find that there is an irretrievable breakdown of marriage. That doesn't depend upon, my lord, that is not completely, my lord, jettison the question of fault. There could be a fault. Cruelty is one of the fault, is predicated on a fault theory. One can't completely jettison it out of question. But what I respectfully submit that, my lord, your lordships discerning from the facts and circumstances or the materials that emerge out of the case, when it comes to your lordship's level, that this is one of those cases where irretrievable breakdown of marriage will have to be inferred. And therefore, your lordship's exercise power under 142, my lord, is a different matter. I'm saying that when your lordships lay down the law now, that it could also come within the broad ambit of cruelty, then I would respectfully submit that then the power of deciding that there is an irretrievable breakdown of marriage and granting a dissolution, if to be made available to the trial court or the high court, would at least require one caveat. That is one of those cases where cruelty is alleged to be one of the grounds on which the party seeks dissolution of marriage. At least that must be. Otherwise, my lord, the statutory parameters may be completely casualized.
Because if you see 23(1)(a), it has two parts.
Yes.
It says that court can pass a decree only if it is satisfied that ground exists.
Correct.
And latter part is fault.
Correct.
Therefore, there is a feeling of cruelty in some form.
Yes. The court cannot enter a satisfaction unless one of the party pleads, my lord, because that is also required. My lord, it would be there. It would be there.
What will be the extent of pleadings? That's another issue.
Yeah, that's a different matter.
Ground of cruelty has to be pleaded.
Yes, but it must be there. And if it is there, and on the materials, the court is in a position to come to the conclusion that there has been cruelty made out, but then the court, that one of the part, that if cruelty made out, my lord, in view of any of the broad parameters that has been articulated here, then, my lord, I would respectfully submit, and the court finds that there is an irretrievable breakdown of marriage, the court can clearly put it under cruelty, mental cruelty, and then still grant a divorce. That is insofar as the trial court and the high court is concerned. When it comes to this honorable court, I would respectfully submit that maybe no such constraints which are otherwise applicable to the high court or the trial court should be applied, my lord, when it comes to the Supreme Court exercising powers under Article 1. Now, my lords, second question is whether the power should be exercised at all or not. It should not be exercised, or it should be exercised, my lord, in the facts and circumstances of the case. In my respectful submission, it should be exercised, my lord, in appropriate cases. And what is it, my lord? It's a repository of a power on the highest court of the land. And if the honorable court cannot exercise power under Article 142 when justice requires to do so, when, my lord, injustice is to be addressed, then, my lord, I don't think we will be paying heed to what this honorable court has held, my lord, over the years as to the final repository of power, my lord, in the Supreme Court under Article 142. That is how it has always done. We do it to do complete justice between the parties. It could be, my lord, in a fundamental rights case, it could be in a tax issue, it could be anywhere. There is no, that's what I submit, my lord, it is not cabined or confined by any other provision of law. It is treated as plenary in character. It has been held to be declaratory of the power that is vested in the Supreme Court otherwise. And therefore, my lord, it cannot be restricted in any manner. And therefore, my lords, in appropriate cases, where your lordships find that ex debitio justitiae, the parties should be directed to go their separate ways, this honorable court could interfere under Article 142. Now, my lords, this takes care of questions 2 and 3. Now, my lords, yes. Now, my lord, if your lordships kindly come to this thing, volume 1. Yes. My lord, my written submissions are at page 12 to 17. No, I'm sorry. At page 20 to 25. Question 2 at page 20 whether the exercise of such jurisdiction under Article 142 should not be made at all, or whether such exercise should be left to be determined accident. Answer now. And the third question is what your lordships had formulated, my lord, at the last hearing. That again, my lord, I have extracted. Next page, my lord, page 23. The orders are also placed on the whether the power under Article 142 of the Constitution of India is inhibited in any manner in a scenario where there is an irretrievable breakdown of marriage in the opinion of the court, but one of the parties is not consenting. That is also, my lord, I just attempted to answer your lordships. Answer that question. My lord, the first question is what could be the broad parameters for exercise of powers under Article 142 of the Constitution to dissolve a marriage between the consenting parties without referring the parties to the family court to wait for the mandatory period prescribed under Section 13B of the Hindu Marriage Act. Again, my lord, your lordships have confined into a question of Article 142. Now, my lord, can I just read for a moment, my lord, just these 1.5 pages, and then, my lord, I'll just make a submission of that. Question 1. What could be the, I've just read the question. Then, my lord, the first part of it, I only reproduce. Lordships would have also noted that Section 13B, the analogous section under the Special Marriage Act is Section 28. Then, my lords, the first paragraph beginning at page 21. The period of 6 months mentioned in Section 13B2 is referred to as a cooling period by this Honorable Court in several judgments. Largely, this Honorable Court has held in several judgments that the 6 months period referred to in Section 13B2 need not be considered as mandatory when this Honorable Court exercises powers under the Article 142 of the Constitution to dissolve a marriage. The following judgments are relevant. My lord, I have given the judgments. All of them are part of the compilation.
In fact, disagree.
Yes.
One decision takes a view that even family court can get rid of this 6.
Yes, my lord. That is the judgment by Justice Goel.
That's right.
In that Amardeep Singh versus Arvind Kaur, 2017-87. On that, your lordships may consider whether that is required or not. The powers of the Honorable Court under Article 142 of the Constitution are always exercised to be to justice, to complete justice between the parties. Following judgments I have held as follows. I have mentioned these 4 judgments, but not all of them are part of the compilation. The Honorable Court has consistently held that the power under Article 142 is constitutionally conferred on the highest court of the land alone, and the power by itself cannot be considered as confined by any statutory provision. Nevertheless, the self-restraint advised by the Honorable Court and practiced as well as this is that direction under Article 142 cannot be in derogation of any rights under Part 3, including Article 32. It cannot be in direct contravention of any provision of a statute. In the above backdrop, it is submitted that under Article 142, the Honorable Court in appropriate cases direct the cooling period of 6 months to be reduced away by declaring the dissolution of marriage to come into effect immediately, provided parties have already expressed their consent for a dissolution or do so in an appropriate way. It is submitted that such an exercise of power would obviously not be in contravention of any right available to the person concerned in the party, nor will it substantially impinge upon a substantive provision of law. This is because Section 13B1 enables the parties to move an application jointly for a dissolution of marriage, not on the fault of either of them, but on consent. This provision deals with the conferment of a right. It is substantive in character. Therefore, separation of the parties to the marriage for a minimum period of 1 year as a condition precedent for a joint petition for divorce by mutual consent will have to be treated as mandatory. Obviously, this condition would have been invariably fulfilled in any case where the Honorable Court decides to exercise power under Article 142 by granting a decree for dissolution on mutual consent. In contradistinction to subsection 1, subsection 2 of section 13B deals with procedural aspects in essence. At any rate, the prescription of 6 months and 18 months has nothing to do with the conferment of a substantive right on the parties or on the jurisdiction of the court to grant a decree for divorce. In cases where the Honorable Court considers it appropriate to exercise the power under Article 142, a compliance with under section 13B2. Obviously, in such cases, parties would have been litigating over a considerable period of time. And when ultimately the matter reaches the Honorable Court and they decide to go in for a divorce by mutual consent, a further direction to again approach the family court with a petition by mutual consent. Once they render negatory, the clear intent behind the exercise to render complete justice between the parties. It is submitted that the following could be considered under Article 142, as delineated in question 1. Parties have expressed a clear consent to put an end to the relation. The dissolution of the marriage should, in the circumstances at the level of this honorable court, be accompanied by a resolution of all associated custody. Prolongation of the list between the parties could spawn further dispute stroke litigation. This honorable court is convinced that there does not seem to be any possibility of repair or approach move between the parties. He said, my lord, this is just an indication. Of course, my lord, if your lordships feel that further conditions, my lord, may have to be.
Your last sentence in clause A requires modification.
My lord. Page 23.
Let's read it.
This honorable court, there does not seem to be any.
Obviously, this condition would have been invariably fulfilled.
That's small b or
No,
small a.
A last sentence.
Yes. Obviously, this condition would have been invariably fulfilled in any case where the honorable court decides to exercise powers under Article 142. My lord, what I wanted to say, my lord, is that the minimum period of 1 year, obviously, you know, they would have.
No, you're saying that, or you're saying
No, consent, my lord, no.
only on 1 year.
1 year, only on 1
1 year is also can be exempted.
1 year, my lord, I am saying, my lord, 1 year, that's only to draw a distinction, my lord, between subsection 1 and subsection 2.
No, what's
No, that
Partly, my lord, as
you're
a.
right. To that extent, you're right.
Yes, that's all what I
what
want.
you are trying to say? Even family court could condone period of 6 months, but not 1 year.
Not 1 year.
42 also.
Say that here. That's a matter on which your lordships will have to discuss.
No, that's fine.
That's one of the questions referred, my lord, therefore
That's-
I did not make able to make a submission on that. But just as a matter so that your lordship will probably be thinking about it. My submission, my lord, that power of waiving of the statute.
You're right. You may be right.
Of 6 months should not be conferred, my lord, on the child. That's not necessary. Why this honorable court exercises power under? Because the parties have been litigating for a long time. And therefore, my lord, to tell them now, you go back, now that you have consented for a resolution, you go back, then file a fresh petition for divorce. Nine, 10 SEC 4. It cannot be waived by the family court is what is mentioned.
The point philosophy seems to be that people can be impetuous in their behaviors.
Absolutely. Absolutely.
So give them some time and they should work it out.
Correct.
Therefore, the consistent line appears to be family court can do away with period of 6 months, but not 1 year.
No, family court also. Lord, I would respectfully submit, when it comes as an original proceeding before a family court, it's better to insist on the period of. Lord, it's a completely different scenario when it comes to this honorable. Parties have been litigating, my lord, for ages. And they have been litigating for ages, my lord, on consented ground, on contested grounds. Therefore, by the time they come up to the honorable court, they would have probably gone weary, my lord, of all this fighting for all these years. And this, they
So,
would-
Giri, once we accept that they have to be living separately or separation for a period of 1 year,
Yes.
then and then they move by joint application. Sometimes they want to get on with the life.
Life.
They have to move on from the stage.
My lord, when the honorable court lays down it as a law, Lord, when the honorable court exercises power, my lord, obviously, it's at this level. There wouldn't be anything rash on that. But my lord, to give that power to the family court, my lord, across the board, in all cases.
No, even
but
that,
in high-
that judgment qualifies in which cases power can be exercised.
Yeah.
A blanket power given to
Yeah.
the family. 2017 judgment.
Yes. Justice Goel's judgment. Yes.
So that following that judgment, cases have been decided as weak.
This is Indira Banerjee's judgment, but it is not in SEC. I just took the SEC online copy. It's a 229, 234. Where ladyship said, if there is no possibility of a reconciliation, there is no point in prolonging the agreement. But also made a mention, if there is a chance of reconciliation, however little, the cooling period should be ended. It's only because of that. At the initial stage of the litigation, when obviously, they have been living separate. Those are early days. It is possible that they could say, that if they remain again for a period of 6 months, possibly there are grounds of reconciliation. Maybe the family would step in. Something. Therefore, my lord, at that stage, maybe the waiver of a 6 months period. I don't know, Lord. I leave it to your lordship.
See the possibilities. There may be numerous possibilities. I've seen in Delhi Mediation Center, 2 people divorced, custody issue on, went to mediation, mediator, Sadhna Ramchandran persuaded them to live in the same house for the benefit of the child. Ultimately, she found that the parents were more at least than the party. They got remarried. Possibilities are many. That's why when I was that in Indian system, there are many things which come from both sides, not only a union of 2 parties. In a typical scenario, there are too many people who are rolling.
The only thing is when they come after the separation of 1 year, then they come. And suppose, my lord, the courts are given the extraordinary circumstance. Courts are given, my lord, the power to waive it in every case. That, my lord, it could lead to a rash exercise of this. That's why I submitted, my lord. This honorable court doing it is a completely different matter. To give it to the family court, my lord, lordships may consider whether it is necessary. Lord, I'm most grateful to your lordships.
Thank you.
List of things, my lord. Lord, in every judgment, my lord, if your lordships would like me to do it, my lord, I'll mark the paragraph numbers. Or your lordships may permit me to give a note, giving the paragraph numbers of all those judgments which have been cited.
Yes, Ms. Mona,
Yes, ma'am.
what do you want to add?
Yes, two things.
So I thought let's finish this in 5 minutes
should be asked.
so that we have a different perspective from you. So you would have
The
the benefit.
Sibyl wants to argue before me, so Lord, of course I have to.
That he is an applicant. I
concede
said I'm not allowing any applications, but you have your 5 minutes. You can say what you want to add. Yes, Ms. Mona.
May it please move. Lord, I have filed a written submissions.
Okay.
Lordship may kindly take note of that. Yes, Mr. Savla is also. This is a specially petition. All other matters are transit petitions. Mine is arising out of a specially petition, out of a High Court judgment, and it's a specially petition refusing the grant of divorce on the ground of cruelty. Lord, I'll just inform that our client is 73 years old and fighting this litigation for 22 years. Classic example, Lord. Why this honorable, and according to us, the wife is already remarried, still contesting this list. That's what we filed about. Yes. Yes, she's remarried. We filed a voter list. They may be disputing it. Nevertheless, Lord, I have filed it along with the SLP as well, Lord. I'm just informing. We are not going to merits of the matter today because your lordships are actually determining only the questions of law. Lord, I am not addressing the first issue or the second issue. I am only addressing your lordships on the third issue, Lord. However, Lord, from where Mr. Giri left, Lord, on the question of mutual consent, whether your lordships were contemplating about the giving powers to the trial court about dispensing with the 6 months, Lord, where Mr. Giri was saying that it can be only exercised by this honorable court. Anyway, Lord, it will become redundant because by the time it comes here, unless the trial court is clothed with that power of dispensing with the 6 months, Lord, by the time it travels, many of them may not even be able to travel this far, Lord. By the time it travels to this honorable court, it is more than 6 years at least, Lord, because it goes from stage to the stage. So therefore, the question of only power being exercised by this honorable court and 13B by dispensing with may not be appropriate only to decide about this honorable court. But nevertheless, that issue, Lord, I'm not addressing. I'm just pointing out this could be a difficulty in doing that. And just two things, Lord. Your lordships had said in Ashok Khurra, which actually resulted in, while talking about 142, Lord, your lordship in fact clothed this honorable court with the power of curative jurisdiction as well. which arose from the Rupa Ashok Kurra, which is from the Ashok Kurra judgment, which was read out, in the morning. What was held was a mutual consent was withdrawn later, which resulted in Rupa's judgment, where this honorable court has held that you had the power of even opening a review of a matter not under 32, and this not read with all these powers, which is granted this honorable court. You can even reopen a matter which is closed in a review, unless there are new grounds which are not raised, which are already raised in the review, which a certificate is given by a senior advocate. So that is also a consequential effect of powers of this honorable court, not how this honorable court can extend its powers. Also, to buttress the point which one of Ms. Jaisingh's points, which I had also noted, is that the parents' patria jurisdiction of this honorable court. Your lordships are not even, like your lordship just now said, marriage is not merely between two individuals. It's also between two families coming together. There are many people involved in the question of marriage. When the disputes arise, it is actually the families which are affected. Nobody is talking about the mental health of the child and the family members in the long run.
Families are affected, but families also
Intervene, but subsequently what happens? The product of marriage, the child will not, most of the circumstances, most of the cases, there is a child.
That is always so.
Yes, so therefore, in the interest of the child also, your lordships has gone to the extent of saying, in a case where twins were there, and they were inseparable twins, where there was a PIL brought to this honorable court, parents were refusing to separate the twins. Of course, there was no medical board was ordered here. Parents did not advise, did not go in favor of that. Some good Samaritan approached this honorable court under 32, and it's a reported judgment, in 2013. This honorable court would say, even if the parents are opposing, if it comes to the welfare of the child, this court, in its parents' patria jurisdiction, will go to the extent of passing such directions. So I am inviting, commending this honorable court, under 142, your lordship will combine the jurisdiction of parents' patria as well, while exercising this jurisdiction under 142 to dissolve a marriage and on the ground of irretrievable breakdown. Please take that into consideration, that a child's interest and the family's interest as well is concerned as a parent's patria, my lord. And thirdly, my lord,
Your SLP is tagged with this?
it got tagged, my lord, actually. It got tagged.
In a way, factually also we'll have to deal with it or not?
Sorry?
It may go back to division bench.
It may have to, my lord. In fact, just let me bring this the notice of this honorable court, my lord. It is from Bombay High Court, Lord. Justice Oka is also a party to the impugned judgment, where Justice Oka would say,
After the legal issues.
legal issue, your lordship may, there are,
only hearing of the legal issue.
yes, yes. So I'm not even going into the merits. I'm saying, in fact, irretrievable breakdown was noted.
What's your number?
No, it is 501.6, it should be today. Yeah.
Now, what's the number?
Sorry, SLP to civil 32449. It's
SLP
there on the
number?
written submission.
022?
032.
22449 of 2017.
No, but that's-
Sorry, the zero will not even come. Sorry.
32449.
Yeah, 32449 of 2017.
Order, just take down order in this. Think that insofar as the decision on merits of the SLP is concerned, matter will have to go before bench of two judges. But since the judgment of this, the constitution bench would have a ramification
Yes.
on that case, limited to the aspect being debated before us, the parties have been heard.
Yes.
Except for the parties have been.
We can hear them as Aaj
Correct. Lead time.
Yes, Lord. However, I may be permitted to finish the matters.
We have to finish, but we want to take care of that.
Yes, yes, Lord. Yes, obliged. Lord. Now, kindly, my next submission. The next submission is that, as your lordships had also observed, society has evolved, but law, my lord, has not been able to catch up with the level of, my lord, the advancement that has taken place today. In fact, today, my lords, the society is contemplating a same-sex marriage. The society has already gone into living partner relationship, which is recognized in terms of law. But, my lord, whatever, this honorable court has been able to travel farther and faster than the legislation sometimes, my lord, like in the case of Vishaka. Your lordships passed a direction in 1997 for taking care of offences of sexual harassment in workplaces, my lord, and passed certain directions till the legislation come into place. But it took 16 years for the legislation to come into place, my lord. So therefore, I'm only saying it's something, Save Life Foundation. where Good Samaritan notifications were in place which were not coming into operation. This Honorable Court has gone a step further and then passed certain directions, my lord. Now, I am inviting your lordships to go through the provision 13B, mutual consent. In 142, while exercising this jurisdiction, my lord, your lordship will be only furthering the grounds which are already enumerated is my humble submission, because 13 contemplates certain grounds. My lord, 1A of 13 contemplates judicial separation for 1 year, and then, my lord, restitution of conjugal rights, which when it is decreed and not effected for 1 year, it gives rise to a right to go back to the court for divorce. My lord, by the time when they come here, after a restitution of conjugal decree and they keep waiting, it's more than 1 year. It's at least, my lord, 3 to 4 years of waiting. Would we be advising them to again go back and then say there is a restitution of conjugal rights decree against you for 15 years, which is pending? No, now you go and file a fresh divorce petition. Lord, is it not in complete justice that your lordship will be exercising the power under 142? So these are circumstances where, Lord, your lordship can very well read 13B, mutual consent, which says without any ground whatsoever, two people can go to the court and then say we have got irreconcilable differences, we want to part ways. So why not this irretrievable breakdown can be extended to other grounds which are enumerated in section 13 as well. Irretrievable cannot be a ground as such, Lord, I agree. But when you read as such grounds of cruelty, desertion, or whatever instances which has taken place over a period of time, that as a bundle, my lord, forms a ground of irretrievable breakdown, which your lordship will not then take that into consideration while exercising powers under 142, my lord. Your lordship may kindly see this court, my lord, has gone to the extent of even, my lord, reading down the definition of rape by saying that, my lord, a rape, whether it is committed even by a husband for a girl who is between 15 to 18, can be still considered as a rape, though that part of the legislation was read out and then it was removed, my lord. Though the court says we are not legislating in that judgment, independent thought, Lord, Justice Lokur would write that though we are not, Justice Deepak Gupta and Justice Lokur would write, Lord, though we are not legislating, but this is actually amounting to reading it along with the POXO Act, so that to make it workable, two legislations are workable. Similarly, my lords, your lordship will exercise your lordship's powers to make this, Lord, the what the 1976 amendment contemplated is to make divorce liberalized, which they didn't pursue thereafter, my lord. After 76, there is a complete standstill, though there is, though two law commission reports are there, though there is an amendment bill which never saw the light of the day, there were joint parliamentary standing committee reports, my lord, that nothing has been followed. So all that is there. So nevertheless, my lord, your lordships can read all these into the grounds of the divorce and, my lord, 13B as well. And kindly take that also the parents' petri as well. Lord, today, your lordship will also notice and take judicial notice of the fact, like Ms. Desing also said, Lord, when we talk to youth about marriage, they say it's a noose around the neck and there is no escape route when there is a problem. So therefore, they take to the root of the institution of marriage, which we are all saying that we are wanting to protect, is not getting protected only because, not certain elbow rooms, like they call it, not it's a fabric of the marriage is a fabric of the institution. Marriage is a great institution, which is a fabric of the society. Not that fabric doesn't need always 555 soap, my lord. It also needs a little comforter once in a while. So therefore, my lord, I think it has to be, my lord, attended to, and your lordships are clothed with ample powers under 142. Lord, there are certain judgments which were not read out, which I have put in my compilation, Lord. Just one judgment which is very recent, which is even said to the level of saying that, Lord, though there is no cruelty made out, still only on 142 we are exercising this irretrievable breakdown is there in the marriage, so we are exercising 142.
That we have said it has been exercised.
In Rajendran, it said over and above that, it said there is, your lordship may kindly see that tag number 3 of, sorry, it's 4 of my compilation. 4. Kindly see this, my lord. Tag number 4. The last few paras would very definitely say that, my lord. It follows, my lord, your lordship judgment in Shiva Shankaran, and then it's in para 35, it would say that, my lord, that the judgment is followed. And para 33 is the, but 33, my lord.
They affirm the judgment but exercise 142.
Yes, ma'am. Para 33 is what they are exercising Article 142. However, my lord, they say that Para 29, they are saying there is no merit at all, and therefore there is no argument that they don't sustain. They say there is no cruelty, and every marriage cannot be on that ground. It can't be. Nevertheless, they find there is a subsequent marriage. That is this Rajendran law. And judgment is on that marital rape. The recent judgment, I think it is, or today, it's pronounced today, is that, this honorable court says, in fact, for a girl who wants to abort in an unmarried relationship should actually extend, they have interpreted it to me, it should extend to the married relationship as well, where there can be a marital rape. The right to abortion should be permitted to be exercised. So therefore, the extent of powers of this honorable court to mold the relief and to suit the circumstances and to suit the society's development. Yes, today, it's pronounced, we'll pass it on to the court. We'll pass it on. Deeply obliged.
Different perspective, is there a statutory bar?
And just one thing, from case to case, it can be
Yes,
exercised.
no, you are opposing her in her matter, correct?
Not only on the legal issue.
You are saying it should not be granted.
I am saying that independent of the grounds, it can't be granted.
Can't be granted. So that is what.
For the irritable breakdown also, we'll have to fit it in one of the grounds. And there is a bar under the Family Act, the Hindu Marriage Act. Just point out, according to me, why there is a bar.
Yeah.
That this court, if there is an express bar, then this court can't grant on the ground of breakdown of marriage beyond repair.
Yeah.
If there is an express bar. And I would treat section 23 as an express bar. So let's just 2 lines of section.
Yes.
For a please. 18 proceedings, 23(1). In any proceeding under this act, whether defendant or not, or non-travelers also can't get a judgment, you have to prove your case, whether defendant or not. If the court is satisfied that any of the grounds for granting relief exist, so grounds which are mentioned in the section 13, if they exist, then only you can grant. That is one. Then there is another provision. Lordship will see, my lords, section 23, 1E. There is no other legal ground why relief should not be granted. Then, and in such a case, but not otherwise. So there is a negative aspect also.
Okay.
So not otherwise you can't grant. And my lords, in my respectful submission, if you're granting on the ground under Article 142, kindly fit into the grounds of cruelty or any other grounds which are already enumerated under section 13. And what Mr. Giri pointed out, one judgment, not following that judgment, and giving a citation, it's in my written note also. 2013, volume 5, SCC, page 2 to 6. This court held that if for any reason, if a party is not agreeing for a divorce, then in exercise of mental cruelty, it can be granted on the ground of mental cruelty.
One line, which I wanted to say is the consent of a party who is not consenting has to be inferred by their conduct, and it should be read into.
Both of you are in a prime basis, so colored by your facts. Argue that before the other.
Yes.
No, it's a short note. We have already
Since the question is,
notice there.
but I had also filed the written submissions. Yes.
Malus, kind permission, I am appearing on the lead matter, Malus. Can I just take 2 minutes to answer? Nothing, I won't repeat anything. After Mr. Sibal, if Malus permits.
Okay.
Not more than 2 minutes. Ash.
2 minutes for you. Sibal, 5 minutes for you.
Whatever, 3, 2, 1.
I've always had the expertise of putting it very succinctly and crispy.
I try to do that, but sometimes you don't appreciate that.
I
I try and do it.
I always appreciate a short argument. I can be
Okay, but let's not.
Yeah.
Well, there's 3 broad issues. Number 1, the real issue in a marriage which is broken is maintenance and custody. That's the real issue.
Yes.
Divorce is used, not giving divorce, is used as an instrument to ensure I get the best order on custody and the best order on maintenance. What this court needs to do is to divorce these 2 issues. These are 2 separate issues. The core issue in a marriage, if it is not working, is maintenance and custody.
No, there is another issue also in the Indian context. I have dealt with umpteen number of cases where sometimes I told you the women have gone as far as to say, yes, he is married another, he has a child. Then both women have equal status, but don't take away my status.
No, but I'm coming to that. That's a separate issue. What I'm saying is, Malad, Malad, in India, marriage at the inception is a social contract. Once the marriage has taken place, then it becomes a matter of choice. Now, that social contract, as my learned colleague said, involves family, it involves caste,
Many factors.
many factors. So when you enter into that marriage, Malad, it's part of that social contract. Now, after 3 years, 4 years, 5 years, you feel I can't live. Now, that's personal autonomy. That's choice. That's can't be wasting my life from 40 to 55. The petition for divorce. Losing my life in the process.
You were not there when Mr. Indra Jaising was there.
I'm just saying.
She said you had a choice, you could have done this when you were the law minister.
So, Manoj, therefore, the point that I'm making is there is an issue of personal autonomy and there's an issue of social contract. And therefore, that power should not be given to the trial court, that power should be exercised by you. Now, the question is, how do you exercise that power? What's the procedure? Well, I dare say, to prove cruelty is almost impossible. To prove adultery is almost impossible. Well,
Many cases succeed.
no, but in the context, well, of course cases succeed, but in the context, it's very, very difficult. It carries on for years. Therefore, so Malas, by the time you come to this court, Malas, the marriage is over. And then you will consider it, Malas, and the most precious.
What is the solution
I'm
at
coming.
the level? Because we know that all these cases drawn. So one of the argument was, when you were not there, that if you are saying there's an irretrievable breakdown of marriage, there has to be fact-finding.
Correct. I was coming.
Irretrievable.
I knew, Malas, I'm coming to that. I had three more minutes, Malas. I'll come to that. Now, Malas, when you divorce when you segregate divorce from maintenance and custody, then you can file affidavits. Now you come to the procedure before the trial court, the family court, saying this is what has happened, this is how he is adulterous, or this is how he is dealt with me. That response in affidavit will come, and the trial judge can come, family court can come to the conclusion that prima facie, this seems, and the test has to be much lower than the test that is applied normally. Much lower. And if prima facie comes to that conclusion, that matter, the family court can't grant divorce, but it can come to that prima facie finding. That will shorten the entire process of litigation. You can come then to the High Court and come in 142 for you to grant the divorce. So please appreciate that the process is as important as anything else. If the process gets prolonged, 21 is effective. Whereas I have a case, and I've done several of them, where there is adultery. We know there is adultery. The father says, have a DNA test. Or the wife says, have a DNA test. He says, I won't have a DNA test. So then what happens? You can prove it. You know it. Where do you go? What do you do?
So Indra Jaising was saying that there has to be a structure for which he, of course, said that legislature somehow didn't take the call, which is irretrievable breakdown of marriage coupled with sharing of we call it wealth or means between the two parties who are married. If that financial aspect is taken care of, she says and that's she gave examples of such kind of provision elsewhere in the world, where it is always structured with a financial. So even when it didn't pass the muster in Parliament, it was because it was not coupled with a financial structure.
I beg to differ. I tell your lordships why. I beg to differ why, because if you bring in the financials with a divorce, there will never be a settlement. One party will always want. You need to say, see, maintenance has to be granted. What happens in normal courts is interim maintenance, interim custody. We'll decide the matter at the final stage, and then we'll grant custody.
It also comes to the Supreme Court.
That also comes to Supreme Court. In the meantime, people have lost their lives. So you need to evolve a procedure. A procedure, which is not inconsistent with the law. That's what you need to do.
You can do much better if when you are there, some lead is taken to bring in, analyze law. Is it not? I'm not talking lightly. I'm actually saying that, if a parliamentary subcommittee would debate it out, bring a law into force,
Won't happen.
it will take care of so many things.
It won't happen. Honestly, tell you, it won't happen. There are too many cross currents in society for that to happen so easily. But that's why you need to, Manas, you need to evolve a procedure consistent with Article 21 in the context of what should happen in a family court without giving that power to the family court to come to a conclusion that this marriage actually is no longer viable. Forget about breaking down. It's not a viable proposition. And you cannot allow individuals to lose their lives litigating. And remember, mothers, the child is perhaps more important than the parents. Because the children, the quicker divorce takes place, the quicker the children will settle. The longer the litigation, the longer for the children, it will be traumatic. So you need to evolve a procedure within the family court system, deholds maintenance and custody, because that's the key issue. That can carry on. But on a summary, like you do nowadays, mothers in commercial.
Mr. Simple, you are on this, you're completely at variance with what Mr. Singh had argued. Because of the reason you just now said, we talked about diverse thought processes and diverse situations in the society. Many cases, the divorce is gets stuck up, you're right, because of maintenance, but right to fair maintenance is equally important.
I agree. Manoj, I agree. It's actually the point I'm making, Manoj. That maintenance with resolution will never take place if you integrally link the divorce with the maintenance.
But they are intrinsically linked.
I am not saying no, Manoj. Please appreciate. I'm not saying no. But if you want, Manoj, see, there is a right for the woman and the man to live separately. Manoj, the 1976 judgment of an English court, the judge looking, the woman was in the witness box. The judge says she's a very charming lady, wonderful lady. I don't know why you can't live with her. He said, but don't look at it through your eyes. Through my eyes.
I can't even relate what one litigant said to the judge.
So the point is, Manoj, what may
I
seem
can't human
correct, what may seem not cruel to the judge, what may seem not cruel to the judge may seem cruel to the individual. Well, it's all completely subject.
There is in an interpersonal relationship, there is always be a personal likes, dislikes. There is two very good human beings may not be good partners.
That's why
they can live together perfectly fine, but when they get married, there's something.
So therefore, a lower threshold. Manoj, that's precisely the point I'm making. Lower threshold of proof. Lower threshold of proof, Manoj, means not a viable marriage. And that's enough to fit in with the statute. Now, because it's impossible to prove these things. And forget impossibility. The nature of litigation is such that it takes years by the time the man or the woman have lost their lives.
That's the unfortunate part of all litigation now.
I'm sorry?
That's the unfortunate
No,
part
but that's,
of many litigation.
here it is personal liberty and personal autonomy. There's the difference for this. Here's the Article 21 report. Because, the best years of my life, I think, 35 to 50. If you're litigating between 35 to 50 and you don't have a divorce, the end of the matter. What do you lived for? You can't get it again. So you need, in the context of 21, you need to evolve a
So
procedure.
Dave is not agreeing, I'm not agreeing that that's the only best part of your life. I look, post-retirement is the best part of my life.
But I'm chiefly obliged. I'll just like to make some
Yes.
signals. We'll give
Just
our
2 minutes.
2 minutes to you, and after that, the remaining 35, 37 minutes are for Mr. Dave.
I wish to address only on the issue of 6 months waiver by the family court. But section 13(1)(b) has subsection 1 and subsection 2, my lords. But in Amardeep Singh's case, this honorable court has held that subsection 1 of 13(b) is a mandatory provision which requires a 1-year period. But subsection 2, my lords, is a directory provision. So therefore, my lords, in particular facts and circumstances of the case, the period of 6 months is not mandatory and it can be waived. So once it is held that it can be waived, my lords, and it's some directory provision, then my lords, that power can be exercised also by the family courts as well as the High Court. And my lords have been careful enough to lay down the criteria or the basis on which the delay can be controlled. So it's not an unrestricted discretion. Now let's me just see paragraph 19 at page 18 in the compilation which I have handed over. Now let's see.
Right.
Page 18, para 19.
Yes.
Now it's the paragraph 19. Applying the above to the present situation. Page 18, minutes, paragraph 19.
Yes.
Applying the above to the present situation, we are of the view that where the court dealing with the matter is satisfied that a case is made out to waive the statutory period under section 13B2, it can do so after considering the following. Number one, the statutory period of 6 months specified in section 13(2)(b, in addition to the statutory period of 1 year under 13(b)(1) of the separation of the parties is already over before the first motion itself. Second, all efforts for mediation, conciliation, including efforts in terms of Order 32A, Rule 3 CPC, Section 23(2) of the Act, Section 9 of the Families Courts Act, to reunite the parties have failed, and there is no likelihood of success in that direction by any further efforts, that the parties have genuinely settled their differences, including alimony, custody of child, or any other pending issues between the parties. The waiting period will only prolong their agony. So, my lords, only with these criteria is fulfilled, then this period of 6 months can be waived. So therefore, once it is held that this provision is not mandatory and directory, then even an application for waiver of this 6 months can be entertained by the family court as well as the High Court. And these criteria have to be applied before any such application for waiver is allowed. My lords, this further criteria has been elaborated, my lords, in the judgment of 2021, Anil Kumar's case, my lords, which we, my lords, will find at page 24, para 27. Amit Kumar versus Suman Beniwal, page 24. My lords, may just have para 27. My lords, in this case,
Various parameters.
that's right. So, my lords, in my respectful submission, if these parameters,
Whatever, however good or bad marriage may be, marriage is a marriage, it doesn't violate Article 21. Everybody is considered for exercise of power. It shall be exercised in that manner and in no other manner. Well, that's been affirmative and his colleagues. Well, it was pointed out by none other than Mr. Allagiri Swami, to the Constituent Assembly, that this is very, very faulty and we must find a solution to it. So, my lord, this draft was amended, and my lord, in that draft, these words were added. The Supreme Court, in exercise of its jurisdiction, may pass any decree or make any order as it is necessary for doing complete justice in any cause or matter pending before it, and any decree passed or order made by Supreme Court shall be executable throughout territory of India. Lord, this was debated on 14th of 1947 by the drafting committee, and ultimately Dr. Ambedkar, when he presented the draft, he said that yes, this is important, and that's how was born Article 118, which corresponds to Article 140. Sadly, Lord, the Constituent Assembly debates are completely silent on 118. Not a whisper about it. I have gone through the entire debates. Now, Lord, that's why 142 is not an independent power. 142 is a power in aid of Supreme Court's powers under 131, 132, 133, 134A and Lord 136. And it is in that context your lordships have viewed it. Now, Lord, see two judgments and your lordships, it will become very clear. Lord, kindly turn first to, Lord, I must first begin by, and don't turn to this judgment, Mr. Librarian, and don't give this. 1986, just kindly note, and this is what worries me the most, because Lord, recently your lordship's judgment in an income tax case has revived 90,000 show cause notices which had abated because section 148 was deleted and new section 148A was inserted. Now, however, Lord, laudable the object behind the judgment may be, Lord, these are matters which create, Lord, extraordinary situation. The judgment which Ms. Jaising cited last, Lord, of Justice Gogoi, which says voice samples can be taken, is in teeth of a judgment of your Lordship's court in Selby's case, where I was assisting the court as amicus. And your Lordship's court came to the conclusion after a detailed debate hearing every Lord State and the Solicitor General, late Mr. Gulal Mohanuddin, to conclude, Lord, and accepted my submissions that narco-analysis test, brain mapping test, and what was it? The three tests, Lord, narco-analysis, and the three tests which could not be compulsorily administered to the accused. And Lord, that would violate Article 20 subarticles. Following Lord, long line of judgments of your Lordship's court in MP Sharma, Kati Kalu, and Nandini Satpathy cases. And Lord, at that time, I must tell your Lordships, Lord, the court was actually extremely concerned about the Lord law and order situation in the country, especially Lord dealing with terrorism. And the court asked me repeatedly when I began at the end that, Mr. Dave, why should we not have, how do we fight terrorism? And Lord, I opened my arguments by reading a judgment of the Constitutional Court of Israel, in which, Lord, similar methods to extract, Lord, information and confession on Palestinian prisoners was, Lord, subject matter of challenge. The Israeli Supreme Court said that however much it is a question of very existence of Israel, this court cannot forget and forgo basic human values. And we will not allow these methods to be adopted by our security agencies. And that, Lord, led to, Lord, thinking on the part of the bench, Chief Justice Balakrishnan, Justice Ravindran, and Justice Panchal. And Lord, ultimately, by a very beautiful, Lord, that judgment is really very extraordinarily well considered. Lord, in 2010, Lord, just note down, 2010, 7 Supreme Court cases, 263. Where your Lordships, Lord, now, Lord, these are issues. Now, Justice Gogoi's, Lord, bench does not consider this judgment and has come to the conclusion that, yes, the law is silent, therefore we will allow our courts to take voice samples of the accused. Lord, it completely negates the basic principles of criminal jurisprudence, burden of proof on the prosecution, right to remain silent, which is sacrosanct. Now, Lord, I respectfully submit that, therefore, your Lordship should not be guided by these equitable considerations. Lord, everybody is concerned about pendency. A laborer who has been waiting for 25 years to get reinstatement and back wages is as much concerned. His Article 21 is more seriously violated than somebody in marriage who is now, Lord, wanting a divorce. So, Lord, these are extraordinary. Yes, these are challenges. But I would, Lord, beseech your Lordships not to be not to be influenced by the fact that, Lord, ultimately these parties who have entered into marriage and, Lord, are unable to now live together, Lord, they must separate as quickly, and therefore this court must exercise extraordinary power. In fact, their power does not exist, as your Lordships have said. And Lord, that is what I will make it good. Now, Lord, in this judgment, 1986, 2 Supreme Court cases, Lord, page 666, para 10, don't turn to it. But Lord, this is a warning which I have always, Lord, reminded myself about whenever I, Lord, want to argue a case where I need, Lord, extraordinary relief from the court. Sri Venugopal suggested, Lord, this is very important, para 10. Lord, this was a question of, Lord, students who were admitted to a medical college and, Lord, excess of quota, the college was not recognized. Mr. Venugopal said that, therefore, you use your extraordinary powers and now allow them to continue. Lord, this is what said. Sri Venugopal suggested that we might issue appropriate directions to university to protect the interest of the student. We do not think that we can possibly accede to the request made by Sri Venugopal on behalf of the students. Any direction of the nature sought by Sri Venugopal would be in clear transgression of the provisions of the University Act and regulations of the university. We cannot, by our fiat, direct university to disobey the statute to which it owes its existence and regulations made by university. We cannot imagine anything more destructive of the rule of law than a direction by this court to disobey the laws. Now, Lord, that's precisely what is being sought from your Lordships. And it was, now please see, 61 Supreme Court. From what I said, Lord, the 61 Supreme Court was an interesting case. Lord, this is that KM Nanavati case, famous, Lord, your Lordships are aware. But one passage clearly signifies Why this Lord vacuum in giving Supreme Court actual powers to grant reliefs in appeals that it is going to hear? Lord, how it came about and what is the purpose of that? Just one paragraph, your lordships will not see. Kindly turn. Para 19, right column, right page. Not para 19 begins on the left side,
Yes.
but on the right side, not just after the quotation. It is noteworthy that the reprieve granted in that case covered only the period until the grant or refusal of petition for leave to appeal and did not go further so as to cover the period of pendency of the appeal of Privy Council. Unlike the order now impugned in this case, the power which was vested in the Crown to grant special leave to appeal to convicted persons from India has now been conferred on this count under Article 136. The power under Article 136 can be exercised in respect of any judgment, decree, determination, sentence, or order in any cause or matter passed made by any court or tribunal in territory of India. This wide and comprehensive power in respect of any determination by any court or tribunal must carry with it the power to pass orders incidental or ancillary to the exercise of that power. Hence, the wide powers given to this court under Article 142 to make such order as is necessary for doing complete justice in any cause or matter pending before it. So, Lord, 142 is squarely related to 136. It's not independent power as has been understood or with Lord great humility misunderstood so far. Now, this one was made amply clear by your Lordship's Court in Premchand Garg, Constitution Bench. But their rule of your Lordship's Court framed under Article 145 was challenged, which said that in respect of matters involving fundamental rights under Article 32, costs can be imposed by your Lordship's Court. That was challenged. Your Lordship said it's unconstitutional. In deciding that, your Lordship said, the Solicitor General said, but you have powers under 142. Why can't you exercise powers under 142? And to that, your Lordships interpreted 142 and answered. Kindly, this judgment requires little detail here, reading. This is 1963 Supplement Supreme Court Report 885. Justice Gajendra Gadkar speaking for the court, gave a beautiful exposition.
It's there in the compilation.
Justice Shah was
It's there in the message. It is compilation also.
दुबे ने कोई नोट नहीं दिया.
It's 235.
So the way you haven't given any note.
No. I'll do not at the end of my argument. Generally, I like to give because I don't like to give something that I have not argued. I only confine myself to what I have actually placed before your Lordships. It's not fair to the court to not put everything and then not even deal with it. Or sometimes we give submissions and put in it what we have not argued. Not that I think is a little. Now, Lord, kindly turn straight away in this judgment to page 895 first. Lord, 885, my Lord Justice Khanna.
I've got it. I've got it.
At 895. 895 first para, last 5 lines. Therefore, we do not see how it is possible to escape the conclusion retards the assertion or vindication of fundamental rights under Article 32, and in that sense must be held to contravene the said right. Lord, as Ambedkar said, that if he had to put his finger on any one provision of the Constitution, which to him was the most important, he said 32. And he bitterly criticized the original draft which was given to the Constituent Assembly framed by Pandit Nehru and his colleagues, saying that you have given rights, but you have not provided any remedy. On the first day of the Constituent Assembly, his speech is good. He was suddenly called upon by President to speak. And he told President that I thought my turn will come tomorrow. President said, no, Dr. Rajendra Prasad, please, I address today on this draft. And when he gives that, he says that what good is a constitution if it only gives rights and not give remedy? That's how was born 30 and 226. Now, please see, that's why it's fundamental right. Now, next page, 896. It is, however, urged by the learned Solicitor General that the powers of this court under Article 142 are very wide and cannot be controlled by Article 13. He has put his argument in two ways. He urges that the words used in Article 142 are very wide, and since they constitute the constitutional character of this court's power, they must be very liberally construed. This contention is undoubtedly well-founded. Give me 142. 142.1 provides that in exercise of its jurisdiction, this court may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it. And it adds that a decree or order so made shall be enforceable throughout the territory of India in manner prescribed by any law made by Parliament, and until provision in that behalf is made in such manner as President may or by order prescribed. Solicitor General wants us to compare 142.1 with Article 194.3, and he suggests that just as powers and privileges and immunities specified by latter article are not subject to provisions in respect of fundamental right, so is the power specified. So those are the rights of the members of the Parliament and Legislative Assembly. The powers specified by Article 142.1 are not subject to the same rights. He relied upon certain judgment. Now kindly turn to next page 892. Lord, before I read that, I must read 142. And Lord, this is Lord the crux. Supreme Court in the exercise of its jurisdiction. 142 begins with a caveat. Supreme Court in exercise of its jurisdiction may pass such decree or order. Now, if therefore, Lord, 136, 132, 133, 134. Not Lord anything else. Now see Lord 898. Basing himself on this decision, Solicitor General argues that power conferred on this court under Article 142 is comparable to privileges claimed by members of state legislatures under later part of Article 194.3. And so there can be no question of striking down an order passed by this court under 142.1 on the ground that it is inconsistent with Article 32. It would be noticed that this argument proceeds on the basis that order for security infringes fundamental right guaranteed by Article 32. And it suggests that Article 141, this court has jurisdiction to pass such an order. In our opinion, the argument thus presented is misconceived. In this connection, it's necessary to appreciate the actual decision in the case of Sharma and its effect. Then, Lord, your Lordships, Lord, go into Sharma's judgment. Now, Lord, kindly turn last 4 lines, Lord. The position of an order made either under the rules framed by this court or under the jurisdiction of this court under Article 142.1 can be of no different. If this aspect of matter is borne in mind, there would be no difficulty in rejecting Solicitor General's argument based on 142.1. The powers of this court are no doubt very wide, and they are intended to be and will always be exercised in the interests of justice. But that is not to say that an order can be made by this court which is inconsistent with fundamental rights guaranteed by Part 3 of the Constitution. An order which this court can make in order to do complete justice between the parties must not only be consistent with fundamental rights guaranteed by the Constitution, but it cannot even be inconsistent with substantive provisions of relevant statutory laws. Lord, Parliament has conferred the jurisdiction on district court. District court alone can exercise the powers. Lord, under Motor Vehicles Act, for example, your Lordships have given judgment, Constitution bench already arose from Mysore or somewhere, I remember, where the question was that appellate authority exercised the power of the subordinate authority. And the argument was, he is an appellate authority, he can. Your Lordship said no. The power is conferred on the subordinate authority. And only subordinate authority can exercise power. Appellate authority cannot exercise that power. Your Lordship's jurisprudence, Lord, in this regard is crystal clear. Your Lordships have never allowed anybody to travel outside the ambit of Lord any statute. If that be so, should this court do it, Lord? In my respectful submission, no. However attractive, however your Lordships may feel that people are suffering, but everybody is suffering. There are millions of litigants who are suffering. 4 crore and 80 lakh litigants are suffering. So what? The answer lies, as your Lordship rightly put it to Mr. Sibal, that government has to do something to ameliorate the situation of litigation. They can't, people can't be called upon for this court to intervene in these kind of matters. It's a constitution to decide. Everybody will come here, see further. Therefore, we do not think that it would be possible to hold that 142(1) confers upon this court powers which can contravene provisions of Article 32. Then our last paragraph. That takes us to the second argument made by Solicitor General that Article 142 and 32 should be reconciled by adoption of rule of harmonious construction. In this connection, we ought to bear in mind that though powers conferred on this court by Article 142 are very wide, and in the same can be exercised for doing complete justice in any case, as we have already observed, this court cannot, even under Article 142(1), make an order plainly inconsistent with express statutory provisions of the substantive law, much less inconsistent with any constitutional provisions. This can therefore be no conflict between 142 and 30. Lord, in the face of this exposition, I respectfully submit that exercise of powers under 142 by your Lordship's court is completely unfair. And this is really the intent, Lord, of the constitutional frameworks. Lord, let me show Lord one aspect. Give me an Ambedkar's word. Lord, this, Lord, September 1949, Lord, please see Dr. Ambedkar warning to us, Lord, in the middle. In fact, Lord, the purpose of Constitution, your Lordships have got that, in the middle. In fact, the purpose of a Constitution is not merely to create the organs of the state. My Lord Justice Collins?
Yes, I think.
Lordships. All your Lordships have that. In fact, the purpose of the Constitution is not merely to create the organs of the state, but to limit their authority. Because if no limitation was imposed upon the authority of the organs, there will be complete tyranny and complete oppression. The legislature may be free to frame any law. The executive may be free to take any decision. And the Supreme Court may be free to give any interpretation of the law. It would result in utter chaos. Lord, these words of warning are not without justification. Lord, this man had a foresight which was unbelievable. That's why he repeatedly warned that Constitution will fail not because Lord, the draft is done, but because people will fail. And he says, I don't know what kind of people they will elect as their representatives and what will happen. Repeatedly, in every one of his speeches, your Lordship should see the warning. He went to the extent of saying that will democracy fail? And he answers by saying, yes, if there is a landslide, there is every possibility that there will be democracy in form and not in fact. Very prophetic. Very, very prophetic. So Lord, I respectfully submit that this is how your Lordships have not consistently viewed this matter. Lord, very few Lord, judgments have really gone into this. Lord Golaknath did in fact say on 142, I don't need to detail your Lordship, but Golaknath was upset by Lord the larger bench judgments. So Lord Golaknath no longer is law in that sense. And only judgment which really speaks on this issue is Lord this decision of your Lordships in Premchand's case. Lord, no. That is already been read. That is my mistake. Lord, Lord, on the citation, I'll just give the citation. Don't kindly turn to it. Mr. Librarian, kindly don't trouble Lordships. But Lord, on this aspect, that Lord, when a statute prescribes a particular way that power must be exercised in that, Lord, a Constitution bench judgment of your Lordships is in CIT versus Anjum Aswal. 2002, 1 Supreme Court cases 633.
2002, 1.
Supreme Court case 633.
It's an age-old principle. If it has to be done in a particular manner, in that manner alone it has to be.
That's it.
This was that settlement commission.
Correct. And Shiv Kumar Chadda, Lord, MCT judgment of Justice, Lord, very beautifully, Lord, he has discussed.
He who holds the procedural sword must perish with the sword.
Correct, Lord, absolutely. So, Lord, this is also, Lord, a constitutional bench judgment, Daswala. So, Lord, I respectfully submit. Now, look at, Lord, what is troubling me is this. Lord, please turn, for example, to the Act. It's all right, Lord. The Act, Lord, expressly provides, Lord, 13B, a particular procedure, and says, subject to provisions of this Act, a petition for dissolution of marriage by decree of divorce may be presented to the district court.
Somewhere between the file is possible. I'll share it with you.
Copy of the section.
Yes.
13B. Subject to the provisions of this Act, a petition for dissolution of marriage by decree of divorce may be presented to the district court by both parties. So, Lord, I respectfully submit that this is a classic case where the word may is required to be interpreted as shall. Because, Lord, that's what the purpose is. Now, Lord, district court is defined in section 19, where it will go, Lord, the jurisdiction is conferred, where marriage was solemnized, or where parties reside, etc., etc. Now, Lord, what they want is, they want to substitute the words may be presented to the district court by the words may be presented to the Supreme Court. Lord, with great respect, however, Lord, strongly your lordships may feel, however compelling the reasons may be for a particular party or parties, Lord, your lordships are really opening a Pandora's box by entertaining. And I must say, Lord, Lord, many people will be ingenious in approaching this court for many such reliefs in different jurisdictions, in different laws. So, Lord, I don't think your lordship should. Now, please see, Lord, 25. What is troubling me is this.
Mr. Mayor, in section 25, where the decree in proceedings is being said, this is not referred to district court. It's said by any court.
Lord, that not any court is any district court, naturally. Your lordships are right. Because, Lord, it depends on.
That said presentation, it says decree
Lord,
in proceedings.
Your lordships are right, but Lord, one.
Because
Lord,
sometimes the way the decree may not be granted. Suppose the divorce petition is dismissed. Sometimes they
Appeal court grants.
Or Supreme Court. Then we said let the decree of divorce be granted. That's how we pass the order.
Lordship.
My only question to you is this: looking to the limited domain of a family law principle, do you still believe, do you believe that even if parties consent, it cannot be granted? Or do you believe if parties don't consent, it cannot?
Lord, in either case, it cannot.
They
must be relegated to the district.
You feel only that court should be?
Yes. I'll tell your lordships why. Lord, however, Lord, modern we may be today in our approach to marriage. Lord, as they say, marriages are made in heaven. Lord, however, Lord, challenges you may have. Lord, our society, Lord, look at it this way. Your lordships have a vast experience of Western society. The reason why Western societies are breaking up because family as an institution is dying. As an institution is dying. Almost every friend that I have abroad, Lord, is divorced. Almost everybody. And their children are real sufferers. The reason why this procedure is provided is, Lord, pulling is to rethink and rethink. And in large number of cases, as your lordships might not necessarily call rightly observed, many a times, Lord, couples want to get back to each other. So in a hurry, just because two of them are not wanting to reconcile, they present a petition to Supreme Court and say, pass a decree under 142.
The way I told, I don't know whether you were here, that my experience of the last 5 years is a little troubling in terms of the profile of the petitions coming in, transfer petitions or otherwise which we are doing, in the time period of marriage. I felt if a data is collected, on a thumb rule, almost 50% are cases of 0 to 3 marriages. I mean, within 3 years of marriages, ostensibly the marriages are
But
false.
I have known of a friend who's not a dear friend whose daughter married, went on honeymoon, came back and wanted a divorce. What do you do with these children? Should the court not put a stamp on it? I mean, are these marriages so casual that not
One day, the way stumped out of after the marriage and never worked.
nothing
Okay.
and there was nothing
And this is
that
not-
boy did to her.
No, this is not only the troubling part is these are not only arranged marriages. They include what may be
Love
classified
marriages.
as love marriages.
Yes.
They include marriages after people have stayed together pre-marriage in a Indian context, a little non-conventional way. Then married after spending a couple of years together, but still have not worked out. So there is.
Correct, I agree, my lord. But not as I said, not everybody look at not today. Your lordships have come across hundreds of cases where employers dismiss their employees without any justification. Those employees are languishing for justice for 10, 20, 30 years.
It's a different issue.
No, it's not. People can come here and say that force the employer for a settlement. Why not?
That's an
I can say pass a
how
decree
to
under
decide
142.
that. I think that's an issue of how to expedite this huge
That's-
areas and it needs, I've always
No, I am only-
legislative challenges, it needs, it's a challenge to the legislature to debate it out.
Not
It doesn't
only,
happen.
but it's a challenge to us as an
That's why-
institution.
That is why I put it to Mr. Simban that since he occupies another position also, but he says it can't be done there.
But also law minister once, a very not successful law minister. But not as an
He was not there when she attributed to him that he should have done it as law minister.
But I must say, not as an institution, both not the bench and the bar, we both owe our citizens not speedy justice. Undoubtedly, we both owe. And your lordships have much greater responsibility because be sure that executive is not going to come to your head. It is only internal, introspection that can
Whenever
be.
sharpening introspection takes place,
Yes.
no, you have a wide experience. Nowhere in the world, as far as I know, there are these volumes of litigation in courts. The government is more than a 50% litigant.
So,
No, how many? I mean, I'm not the extreme stages of a US Supreme Court. They decide about 100 cases a year. But I would like to know any other court.
nobody,
Is
nowhere.
even able to deal with a fraction of these cases. The latter side, I used to tell once a team of foreign judges came and they sat with us on the bench when I was in the High Court. And I said, give them this dispute about direct recruits and promotees in the judicial service and let them sort this out in 1 year. You give it to them. How many judgments have come? How many views have been propounded? And some of these are perennial disputes which don't sort out.
But not with 140 crore people, our per capita ratio of judges is perhaps the lowest. in the world. The executive is not interested in it. Rule of law is failing on people are
So
losing
the fear
fear.
of the scrutiny also.
My distinguished friend Mohana rightly says now people don't want to marry, they want to have living relationship. That's it's not out of choice, it's out of compulsion because they know that if we do get married and if we do have to separate, there is no way we can separate. So, Lord, it is a very serious social challenge.
This issue of how many tiers of scrutiny should a system have? Should a revenue tier of scrutiny, I keep posing on a lighter side this for the court, should we interfere in the 7th court, the 6th court? Were there a court above us, I'm sure 50% of our orders would also be over.
Yes, Your Lordship said once, we are final not because we are final, but because we are last.
Yes.
So if somebody was above.
So I think somewhere it has to be fixed as to how many tiers of scrutiny should a particular nature of litigation go through. All of us are fallible. There's no guarantee that what we say is right.
So Lord, now just see 25, Lord, for example, 25, 2 and 3.
Yes.
Lord, why does district court retain that jurisdiction? 25, 2. If the court is satisfied that there is a change in the circumstances of either party at any time after it has made an order under subsection 1, it may at the instance of either party vary, modify or resign any such order in such manner as court may permit. Justice. Now once you have passed an order in Supreme Court, nobody has a remedy. Nobody can do anything about it. Same with subsection 3. So if somebody remarries and not the order of alimony is required to be changed, what happens? So, what I respectfully submit that, the Act is a complete code. It's self-contained. In every which way, this act, yes, Lord, the delay is not because of the act. Parliament has given Lord sufficient Lord thought to it. The delay is because of sheer pressure, sheer population.
That's a different,
That's it.
separate
So,
problem.
Therefore, not to short circuit and say that this court should exercise powers under 142, Lord, in my respectful submission, is totally uncalled for. And I am, Lord, with all humility at my command, I respectfully submit that, Lord, your Lordship should not exercise powers under 142 in this. Those are my respectful submissions. Deeply grateful.
You were saying, what if the Supreme Court says something? Just find out the data of how many reviews and how many curative petitions every week are filed on
I agree with you.
I realize now, being party to all curative petitions, what is happening?
Lord, I must say one thing. I have only signed one, or at the instance of Legal Aid Committee. And I was never informed by Legal Aid Committee about the fate of that. It was a criminal matter, very serious matter. And it required me not to be cured.
It happens. I agree.
But I
I'm
was
party to order recently, we have allowed on a historic ground of
But your
curative
Lordship-
petitions to restore review.
Lord, your Lordships will get a chance, Lord, to preside the Legal Aid Committee of Supreme Court. Time has come when all Lord senior lawyers should be at least given 10 matters a month. I have been begging. I was member of Nalsar for 5 years. I said that please, not one matter is sent to us. Not one matter. And I'm sure every one of us.
In fact, I had also mentioned last time to the legal aid people that they have not been actually sending regularly.
And you can't find better assistance than in Mr.
We don't
Kiso or
mind
Ms.
that.
Mona or Ms. Meenakshi.
We should be able to utilize your offers. And there's no reason, no earthly reason, I think.
Lord,
why it should not be.
I have said repeatedly. So Lord, your Lordships may bear in mind.
That's
Soon your Lordships will be.
I'm in the Legal Service Committee.
Yes.
So that I promise some action by tomorrow.
Great.
Just one line.
What's your Lordship?
Just as an aside,
And 3 colleagues of mine.
we treat them with equal seriousness as any other brief that is given.
Absolutely.
No, just one line, Mr. Dave was pointing out 142 said in its jurisdiction. 25 is your lordship jurisdiction, 136 is your lordship jurisdiction, 25 CPC, 406 CRPC is also your lordship jurisdiction. So all that with 142, your lordships will be coupled with that exercise. Not just one thing.
Who are you for?
Amicus.
One of the amicus, but everybody's taken so much time. I have just a very small 3-line submission
Okay.
today.
No, I'm legally obliged.
My
1, 2, 3,
submission
yes.
primarily is that 142 is primarily akin to your old powers of equity, good conscience. Therefore, statutory law does not bind you when you exercise the power under equity and good conscience. And the words that are used in 142 is the jurisdiction of this court. Now, when my lords exercise that power under 142, the court exercises its power under one of its jurisdictions conferred under the Constitution or maybe under the statutory this thing at all. But once it is a jurisdiction of equity and good conscience under 142, then for whatever it takes to carry out that equity, deliver that equity, the court can exercise that power to meet with the ends. That is one aspect. Now, my lords, 142, the court is only bound by other provisions of the Constitution. Not necessarily always the statutory, but the provisions of the Constitution itself. And number 2, it will enable the court to bypass a very cumbersome procedures in interest of justice. Because otherwise, if my lords, in a matter of a matrimonial dispute, if the parties settle here and they are relegated to go back to a trial court and to go through the procedure again, these relationships are so fragile, the settlements are so fragile that we may land up in another round of a litigation.
Both are happening. There are cases where we have settled according to the settlement with the schedule laid down that the first motion will be filed like the second motion will be. So both things are happening. It's a mix, but
My lords, I would clearly say that that's a power that my lords will carefully examine in each particular case. Lastly, my lords, Aaron Barrett said that where you exercise a power of equity and good conscience, and maybe in something like 142, because it's a power which is an extraordinary power, the only circumspection, because it's a matter of a restraint that the court has put upon itself. The Constitution does not prescribe any restraint on the powers of this court, whether it's only in respect of a substantive justice or that it will not cross the statutory limit. It's an exercise of restraint that the court has imposed. Now, that's where Aaron Barak says that if you seek to exercise that restraint, then the only way to do it, provide your reasons why we have exercised that power under 142. The minute the reasons are put in there in that order, and even if it's in one paragraph, on the basis of equity, conscience, and these extenuating facts, we have exercised this power. I think everything else comes to a rest on that particular ground, my lord.
Thank you.
My lords,
Thank you for providing, Mr. Dave, as usual,
Written note of my argument by tomorrow,
as usual, you have provided without restraint a different perspective. We are happy there is one perspective. Thank you.
There are some judgments in our compilation. Please take note. Malati Ravi, which has not been read out. Not so.
One piece, a little like this.
Yes.
Start to be read.
Yes.
These judgments, after a stage, the computerization has created its own problem. These compilations and compilations and compilations get unburdened on us. Of course, we have to really segregate them and do them. But it's your short notes which work us and help us in penning down a judgment.
We have mentioned those.
Notes are in
We have mentioned those in the submission.
I never believe we are professors of law. We are people who decide a list. In the shortest form we can write, the better. Thank you very much.
We have put the submissions with the judgments as well.
Yes, just one request, my lord. It's been a pleasure and a privilege to assist you. But we are also mouthpieces, my lord. There are youngsters who have also put in a lot of hard work.
Please give it. We'll convey them the copies.
Because it encourages them, my lord, to.
So please put down on a piece of paper.
Yes.
The amicus and the other councils who have assisted them. Certainly, I feel it's very necessary to appreciate the younger members.
That's what I thought.
Because one of
the
the, I don't know, your lordships may be aware, one of the rules originally framed by Supreme Court under Article 145 was, well, under the rules, one of the clauses rather, that Constituent Assembly suggested was that Supreme Court should have power to limit the arguments of lawyers. And that was removed. I have seen that.
Mr. Dave, I keep still trying it. I still keep trying.
I don't know why constitutional framers deleted it. It should have been there.
Without being restrictive, I still try to persuade lawyers.
Report which says 3 pages.
Options do crack the whip sometimes, but not certain.
Sometimes it goes very long because I somehow feel if it doesn't hit me in the initial time, it's not going to hit me over a couple of days.
3 pages is this
Sir,
court's
Can we
standard.
just tender the small submission?
3 pages. My list carries the note 3 pages.
3 pages.
We will tender.
Grateful.
Grateful.
Deeply obliged.
Deeply.
Grateful.
Thank you.